Each side will have 15 minutes to present their arguments, and you, as the appellant, will have up to 5 minutes for rebuttal. So you just have to let me know.
And good morning, Your Honor, and thank you. I'm attorney for Mehdi Sagafi, the appellant, the ward's husband. We would desire to reserve a full 5 minutes for my time for rebuttal, please.
Sounds good, thank you.
Here today, we're going to present a brief synopsis of the family history of the Sagafi family, the procedural history of this case. I'd like to initially first briefly explain, though, why we believe the court acted improperly on December 3rd, 2014.
Before you begin,
Yes, sir.
and I know that you briefed this, but could you just spend a couple of minutes in light of the fact that the Cuyahoga County Court has already decided the divorce case, and apparently it is now appealed. Just speak briefly to why you believe that the issue is not moot.
Thank you, Your Honor. Well, the dispute before us, I would respectfully submit, goes to whether it was proper for the divorce to proceed to conclusion at all. The issue,
Which it's already, that's my point, it's already happened.
well, and we think the issue is whether it could have even proceeded to the divorce initially. The fact that it's gotten there since, I mean, I don't think the issue before this court would be different if the divorce case had been continued for another year and it still wasn't final. The issue is, was it an abuse of discretion for the trial court to determine that the ward did not need any capacity evaluation to test whether she actually was sincere in her desire to get divorced, sincere as to whether the desire was coming from her or was coming from third parties through her. So I think the issue goes to the fact that that order, which put everything in motion, was not properly granted, and I don't think the fact that the divorce was granted changes the circumstances of the order December 3rd.
Well, I guess I have two questions in regard to that. First of all, what remedy can we render now?
The court can reverse and remand the December 3rd, 2014 order to the extent that the capacity evaluation of the ward was decided to be not necessary in order for the court to issue power to the guardian to conclude the divorce.
But how would that impact? It's already done. That's what I'm getting at, just like Judge Moore, it's already done, so how do we unring the bell?
Well, I think if it was found...
Even if we ruled what you said, how would that help?
I think it would undo the divorce. I think there'd be a proper motion, 60B motion for reconsideration in the divorce case that would say, look, on further court ruling, forgive me, I believe it's 60B4, I don't recall the specific subsection, but the law has changed at that point, basically.
But wouldn't the issue of capacity be an issue that should have been raised in the divorce case itself anyway?
Your Honor, it should have been raised there, and it was raised there repeatedly.
Then why would we, at this point, have the ability to overturn a separate court from the domestic relations court?
Because the only court that has jurisdiction over the ward to compel her to submit to a neuropsychological evaluation or another capacity evaluation is the trial court here, the probate court. Domestic relations court does not have that jurisdiction.
But the whole idea was to have her submit for the purpose of stopping the filing of the divorce, which now has already happened.
The divorce has been granted, but we believe the predicate that it was granted upon was faulty, and we believe if you take that predicate out, the divorce has to be redone. And the ward has to submit to a capacity evaluation. There's even, I mean, I cited in my brief, family law case, Boyd versus Edwards, Vanderwright versus Vanderwright. I mean, the court has, that's the domestic relations court as well as I believe the probate court. The court has a duty to assure itself that the ward in fact wants a divorce. At that time, the ruling was based on public policy of favoring preservation of the marital bond. But also, I think maybe more specifically, Boyd versus Edwards talked about the court commits an error in not making a prior determination as to whether the ward was sufficiently competent to speak on his own behalf, and if so, in making no inquiry into his personal wishes regarding the divorce.
But counsel, wouldn't it require us to determine that the domestic relations court order of divorce was void?
I don't think that would be the case, Your Honor, especially because this is the 9th District. Obviously, this is the Lorain County Probate Court. It was the Cuyahoga County Common Police Court. That appeal, which is being appealed, is going to the 8th District. I don't think this court would directly be assuming jurisdiction over the Cuyahoga County Domestic Relations Court.
Well, the event is the divorce.
Correct.
I would tend to agree that's probably not void because the trial court didn't patently and unambiguously lack jurisdiction to issue the order. They did it over objection. But that's now on appeal. Don't you, if this isn't moot, you could potentially have conflicting judgments on the issue, couldn't you?
Well, I think there's a
We could issue one order saying, no, you shouldn't have allowed the divorce, and the 8th district say, no, the divorce was fine.
Well, the divorce court in that scenario would be deciding that the ward had sufficient capacity. It wouldn't be deciding whether there was an abuse of discretion. The divorce court would be deciding the ward said she wanted to become divorced, and we believe that the ward had capacity. However, capacity is really and truly a determination for the probate court here. Plus, I think to some extent, there's a jurisdictional priority rule involved here. The probate court has jurisdiction over capacity issues. The divorce court also has jurisdiction to try to figure out if the ward sincerely wants to become divorced. The guardianship was invoked, so both courts have jurisdiction. The probate court was invoked first. The guardianship applications were filed May 3rd, 2013, and the divorce was filed 3 days later. So I think even the ward themselves would not have standing to say that there's a conflicting judgment there.
But isn't the jurisdictional priority rule limited to courts that have concurrent jurisdiction?
It is.
Probate court doesn't have jurisdiction over a divorce case.
And that is true, and it is true about concurrent jurisdiction being a prerequisite. However, I think the court's scenario that's suggested is, are the courts could conflicting judgments come out? And I think the answer is no, because I think the issue to be decided is a little bit different, and I think also both courts have to make some determination about the ward's capacity. Both jurisdictions have been invoked. So I think if anything, the probate courts would be prime because the probate court jurisdiction was invoked first.
I guess just mechanically, if we determined that the domestic relations court order in Cuyahoga County was voidable, as opposed to void, wouldn't that have to be appealed and resolved in the 8th district? The voidability of that order?
We're not asking respectfully this court to directly void or decide that the Cuyahoga County Court's decision was voidable. We're simply asking this court to decide that the Lorain County Probate's Court's December 3rd order was abuse of discretion and reversible error. That's all we're asking. Then we believe we would take that judgment to the Cuyahoga County Common Pleas Court, file some type of 60B motion, maybe a motion to vacate the judgment, and say, look, the probate court never had authority to authorize the guardian to proceed the divorce to conclusion. We point out the superior guardian here in this county has complete and entire control over the junior guardian. So we can say we believe that the junior guardian in the end lacked that authority to proceed the divorce.
And I guess the problem I'm having with it, and I'm still not sure I completely see, is it just seems to me that those were all arguments that probably should have been raised if they were not raised in the divorce proceeding. So I would assume those are going to be assignments of error in the 8th district.
And Your Honor, if I could just say, I was not the attorney on the divorce case. There's a potential conflict between the role for Betty Sagafi in the two courts. I am familiar that that error was raised in the trial court repetitively a number of times by Betty Sagafi's other counsel in the divorce court. I think it will be raised an assignment of error, not specifically as to the probate court's propriety of the December 3rd, 2014 order. I think it'll be raised in the 8th district appeal more on the lines of the ward didn't actually testify. The court didn't ever hear from the ward in that case, so the court couldn't decide that the ward had capacity to decide to become divorced. I think under the rules in Boyd versus Edwards and Vanderwright, that's a prerequisite given the position of the guardian that the ward desired to become divorced and could accurately convey her wishes. So I think, and that's obviously not my appeal, but I think that's how that would be handled, and I think that can be appropriately handled under the rules of civil procedure and the rules of appellate procedure. I think.
How many minutes did you say you wanted to reserve?
5, please.
You're actually only about 20 seconds away from that. We had so many questions.
Okay.
If you want to proceed in your rebuttal, that's fine.
I will proceed in my rebuttal.
I mean, if you want to proceed now with your argument, your rebuttal.
I will, yeah, I'll save my 5 minutes and make my argument. Thank you.
I'm sorry, don't mean to be confusing.
No, thank you, Your Honor.
Good morning, and may it please the court. I think the court accurately apprehends the mootness point. And more to the point that I think each of you has questioned Mr. Hull about. There were 5 different officials and officers of the court, in addition to the court itself, that heard directly from Ms. Bakhtiar about her desire to be divorced. In fact, the probate judge found that she expressed herself, and I'm quoting, clearly and cogently, and found her to be a bright and articulate person in expressing her desire to be divorced.
Of course, we don't, if it's moot, we don't get to any of that.
I understand, but the point that was being made was, by Mr. Hull, was, well, there's never been an expression. The Domestic Relations Court apparently didn't hear this, according to his representation. But certainly the probate court heard it, and the probate court interviewed her itself. There are 2 other reasons why this appeal should either be dismissed or the judgment and order of the probate court should be affirmed beyond the mootness point. The first additional reason for dismissal is that there is no final appealable order here with regard to the December 3, 2014 order simply authorizing the guardian of the estate to proceed with the divorce proceeding. There's obviously 3 ways, as the court is well aware, to have a final appealable order. One is that the order or judgment determines all of the rights and issues and claims of all of the parties to the case. That obviously didn't happen with the December 3, 2014 order. The probate court has proceeded, remains to this day in existence and active with additional issues coming before it post the December 3, 2014 order. So that's obviously not a reason why it was final and appealable. Second, there can be a Rule 54B determination if fewer than all the rights and interests of all the parties have been adjudicated. Here there was no Rule 54B language in the December 3, 2014 order. That's not a basis for this court's appellate jurisdiction. Finally, there is the provision in Revised Code 2505.02 regarding a special proceeding and with a substantial right being affected. Now, I think a guardianship probably is within the definition of a special proceeding. I think there's case law to that effect. However, there was no substantial right on the part of Mr. Sagafi that was being adjudicated by the order simply authorizing the guardian of the estate to proceed with the divorce case. There is no substantial right in the Ohio Constitution, in Ohio statute, or in Ohio case law that someone has the right not to be subjected to a divorce proceeding. Remember, this did not adjudicate the divorce. That was up to the Domestic Relations Court in Cuyahoga County. This was only an order saying the guardian of the estate had the authority to proceed with the divorce case itself in that Domestic Relations Court. That is not an order affecting a substantial right within the meaning of the appellate jurisdictional statute. So for both the mootness point and for the fact that there is no final appealable order that is being appealed from, this appeal should be dismissed. If, in the alternative, the court chooses not to dismiss the case but rather to reach the merits, then I submit to the court that Judge Walther did not abuse his discretion in issuing his order.
So I just want to make sure I understand. So, and I don't mean to point at you with a pencil.
That's all right, Your Honor.
Okay. So I want to make sure I understand. So we would have to have jurisdiction before we could say the issue is moot.
That is an interesting point, Your Honor. I believe that's right. I believe the court would have to have jurisdiction over so the threshold question would be the jurisdictional question. I took the mootness question first simply because the court had addressed that already to my friend on the other side. But I believe as a matter of proceeding with the appeal, you're correct, Your Honor. The court would have to find that it had jurisdiction and overrule my argument that it does not, in order then to address the mootness point, which would be an alternative ground for dismissal.
So if we said it was not a final appealable order, everything would just be left as it was in the probate court proceeding?
Well, that's correct, Your Honor, which raises, I think, the specter, Judge Carr, that you're worried about is down the road when there is finality to the probate court proceeding. Would that allow the issue then to be live and ripe and able to be raised at that time? I think it could, as far as an appeal goes, but of course by that point, I believe the mootness point would be even more compelling. There would be, I don't know if there are degrees of mootness, but it would certainly be a lot more moot a year or two down the road than it is today. Finally, as I was saying, if the court should choose to reach the merits of the appeal, clearly the probate court did not abuse its discretion. The probate court, as I started to say a few minutes ago, heard from the ward herself, found her to be articulate and clear in her expression of her desire to be divorced. And not only did the court hear, but there are 5 officers of the court: the guardian of the estate, the attorney representing Ms. Bakhtiar in the divorce proceeding, the guardian ad litem, the head of the guardian ad litem program, and the investigator, all of whom separately interviewed the ward, all of whom found her to independently express her desire that she wanted to be divorced. So on that basis, there can be no finding of this court that Judge Walther abused his discretion in allowing the guardian of the estate to proceed with the divorce.
How are we to view the evidence in the record regarding the medical evaluation, the psychological evaluation of the ward just before, I'm trying to think of the time, perhaps it was just before the filing of the guardianship, where she was found basically to be incompetent?
Judge Moore, that's right. I mean, she was in need of the guardianship, as all of the parties agreed in October of 2013, which is why Judge Walther canceled the neuropsychological exam that he had set up.
Because
the parties agreed. She was in need of a guardianship. That is a different question, whether she was competent to handle her financial affairs, competent to handle her other affairs of her life, from the issue of whether she was capable of expressing her desire to be divorced from a husband who had not been supporting her, who had committed other acts which led her to want to be divorced from him. That, the court found, on the basis of uncontradicted evidence, she was able clearly to formulate her desire and express her desire. So that's the distinction I would draw, Your Honor. Unless there are further questions from the court, we would ask the court to either dismiss the appeal for lack of jurisdiction, dismiss it for mootness, or affirm the judgment of the probate court.
Thank you.
Thank you.
Your Honors, thank you. I will, just so I can reach the merits of my argument, we have briefed and we have initially prevailed on the issue of a final appealable order. I would just call the court's attention to Noble versus Colwell. Final appealable order resolves a distinct branch of a case. We believe the issue of whether the ward would have to go through a psychological evaluation before the guardian was authorized to proceed completely disposed of that issue. Counsel is correct. Guardianship proceeding is a special proceeding and it did affect a special right. The abuse of discretion comes in many forms, but the fundamental of which is the court accepted testimony from 5 lay witnesses in substitution for expert testimony, which the court itself had ordered 4 times, and the court had observed at least twice on the record was necessary. We look at the sheer change of the life circumstances of the ward. We're comparing 54 years of marriage back to the Eisenhower administration, all the way to 2013, and then the 18 months afterwards. She all of a sudden doesn't want to be married anymore after being married the whole time. She was always close to her sons and her grandchildren. She was specifically estranged from the woman who became her guardian, had no relationship with her really after she testified against that woman in her daughter's own custody battles. We've got expert testimony from Dr. Pickle, the report on file with the court about vulnerability to undue influence, complete loss of executive functioning. We've also got testimony about lack of capacity. So this whole difference between capacity and competence was actually resolved initially by expert testimony. So why do we believe it's an abuse of expert discretion? Quite frankly, the guardian is an attorney. The former guardian is a nurse. The prior guardian, the court investigator, none of these people are medical experts. And I would essentially like to read 2 quotes from the court out loud here that I think illustrate more clearly than I could ever hope to illustrate why the court should not have backed off its initial position, expressed 4 different times in order to then grant the order saying no psychological evaluation was necessary. This is Judge Walter's own words on March 4, 2014. I am, quote, not trained in that area. I am not a psychologist, a psychiatrist, a neurologist, a physician. I have a doctorate of jurisprudence, and that means I can, prescribe Band-Aids and aspirin, and so that's all I can do. Subsequently, July 25th, 2014, so we're now only not even 5 months before the court then granted the order that's subject to the appeal, in open court here, the judge observed Mr. Wolf, the ward's attorney, is not a physician. This is in response to Mr. Wolf saying she has clear capacity. There's no possible way that she couldn't be expressing her wishes correctly. So, quote unquote, Mr. Wolf is not a physician. There's one other important person in this room who is not a physician, and that's me. My problem is I'm being asked on one side to listen to what the ward has to say, and on the other side I am asked not to listen to what the ward has to say. I believe it's important for me to understand how much of what she tells me or how much of what she testifies to eventually is something that I can understand and that she understands. So for that reason, I'm going to order that there be an independent neuropsychiatric evaluation for the purpose of assisting me in determining that she is telling me something that is credible and whether she is saying something that is coming to me as a result of rational thought. He continues, the ward has said that she had desires to become divorced. However, she had made some very inflammatory comments about her treatment that bordered on hyperbole, or not hyperbole, maybe even went past that. It calls into question whether or not the comments she is making to me are that of somebody who is giving me some rational thought and rational comments. And here's the real kicker. I don't know how I would ever put any stock in that without knowing if there's a line that can be drawn along there. It will be my job to find somebody that can do that. July 25th, 2014, the court said expert testimony is necessary to decide capacity. The court already had expert testimony on record saying that there was no capacity. And the court said that he himself would try to, the judge himself would try to find an expert to conduct this evaluation. It never happened. And that's what we believe is not correct. If the ward has capacity, if she desires to become divorced, then we've got to live with that. We fervently believe that she didn't live her life in any way like this. Nothing that's happened since she lost capacity is consistent with any way in which she lived her life while she had capacity for 54 years. And quite frankly, we believe that's reversible error. The superior guardian is a fiduciary to the ward. We believe we don't personally disparage the judge, but we believe that this was something that did not rise to his own responsibilities to the ward to determine her capacity, especially in view of the fact that there's more than adequate resources, financial resources in the guardianship to pay for that extra evaluation. We believe that the circumstance that exists is not anything like what the ward would truly want.
And counsel, you're out.
Okay. Thank you, Your Honor.
Thank you. The court will take the matter under advisement and issue a written opinion and put it on our website. Thank you.
Thank you.